Number 60, matter of Elizabeth Street Garden versus the City of New York.
May it please the court, my name is Norman Siegel. I'm representing the appellants. I respectfully request 12 minutes for argument and 3 for rebuttal.
Yes, sir.
Thank you. This court clearly stated 30 years ago in the matter of Jackson that the heart of CEQA is the environmental impact statement, EIS process. Though the proposed action is a type 1, which carries with the presumption that it is likely to have a significant adverse impact on the environment and may require an EIS. No EIS was employed in this case. In the Friends of PS 163, in 2017, this court said, and I quote, "Opportunity for public participation and engagement is an essential and mandatory."
When there is a determination of that there's not going to be one because of a negative declaration, what is our review?
To arrive at the determination that there's no adverse impact on the environment, 3 things have to be met by the lead agency here.
But as to our review of their determination?
I believe it's that you look at whether or not they participated in identifying the relevant environmental issues. 2, did they take a hard look? Although in looking at the cases for 49 years, it's very difficult to pinpoint and clarify what hard look says. And I would hope that this court would consider seriously in further defining and clarifying what a hard look is.
Well, what else do you think they should have done here? They claim they took a hard look. He'll make his argument. What do you say is deficient and that they should have done to meet the standard?
For example, on public policy, the rule is that you take a look at public policy. Let's take a look at climate change, a critical issue, especially these days. So when you take a look at climate change, the EAS fails to even mention, let alone address, the critical issue of climate change. Nowhere in the 153-page EAS does the words climate change appear. Thus, on that issue alone, not only did they not meet the hard look, I respectfully submit no look. It's clean. That alone should have you send it back to the Supreme Court to then have HPD
Is it your argument that they were required to look at every area of concern that's articulated in the technical manual, or do they have some discretion with respect to identifying which areas of concern they think are appropriate to look at?
This court has said they have discretion. But then comes the question that I respectfully ask. How could you not address the issue of climate change when you're talking about the state environmental law? And even assuming that there is discretion, I would submit that discretion is not unlimited.
But they dealt with the greenhouse emissions. Why isn't that enough?
It's not enough because the greenhouse emissions, they say they look at, we say that you have to look at things like rising urban heat. Nothing. That's a critical issue. Second, the destruction of trees, especially mature trees, which we have plenty, 24 almost in Elizabeth Street Garden. The trees are there to reduce the heat. And when the storms are coming, and the training manual talks about the storms and talks about storm runoff, when you have trees and open green grass, they suck in.
Counsel,
and therefore,
I was intrigued by that.
Thank you.
The tree argument with climate change that you made. And I went back and I looked at the technical manual, and it seems focused, to me, almost exclusively on whether the proposed building is going to be emitting greenhouse gases. I didn't see anything in there about whether trees are going to, I guess, consume greenhouse gases. That doesn't seem to be a consideration that's even articulated in the technical manual. Are you saying that that should have nonetheless been
Yes.
something that they considered?
Because in a lot of other parts of the technical manual, they talk about critical change, climate change, and they talk about the difference between the rising urban heat and the mature trees, in addition to the fossil fuels. But the trees absorb the carbon dioxide as well. They store it, and they reduce the heat, and that's very important. One of the major issues here...
Counsel, I'm sorry to interrupt you. Maybe to put this a different way, this appellate division decision is a couple of pages long, and
Disappointing.
they treat your greenhouse emissions and this argument you've been touching, and it was unanimous, but they granted leave to this court. Do you have an idea of what the issue of statewide, and I understand the issues are very important to your client and to this case, but do you have an idea of what the novel issue, as you said, a lot of these cases you were citing go back a long time, and this may be a disagreement you have over application of those precedents, but what is the novel issue here? What's the issue that this court needs to clarify? Do you think it's this greenhouse gas emissions,
No.
climate change?
Next year is the 50th anniversary of CEQA. When we began 49 years ago, people were unaware of this quintessential threat to people throughout the state of New York. That's why we have a State Environment Quality Review Act. What I think we have to do is recognize not only the dangers of climate change, but the importance of the laws to combat the climate change. And what happened here...
Taking the point of the appellate division that there really are no standards or particular things that could be applied, and I think they do this in a couple of sentences, what would you have this court say on that issue?
Well, to begin with, when the city talks about the standards are amorphous in the appellate division, page 40, footnote 7 of their brief is this report. This report is 63 pages. I read it. 40 city agencies are directed to come up plans, including the lead agency here, HPD. And they talk about the open greenhouse. They talk about the fact that the trees are relevant. The question that you raised before is that Trinity manual was written in 2014, 10 years ago. Very important. The change, give you an example. Governor Cuomo set up a 21st Century Commission. They looked at this and they recommended to put back into CEQA the standard that you have to look at climate change.
So
The current rules say that.
So is in part the argument that to the extent they limited their methodology to perhaps a narrow reading of SECRA, that that's, trying to respond to Judge Garcia, that that's the novel issue, or that's the issue that we need to make some statement that climate change is obviously a concern?
Yes, right on, Your Honor.
So
But
this
second,
court
the other
should
part-
say that climate change is obviously a concern, and what?
The current regulation says that they should address climate change. For
But
example,
what does that mean as a specific matter, and where are there some standards that can appropriately be implemented in the secret process? Where do we find that?
2012 consent decree that the city had with the State Department of Environmental Conservation. They set forth benchmarks for 2012 to 2030.
But aren't those broad? In other words, how does that translate into the evaluation of a specific project on a specific site? And where would you have us find standards to do that?
Executive Orders 26, as well as the 12,000.
But where in 26 is there the kind of specificity that can readily be translated into the secret process?
This report has in 5 instances where they talk about plans to create open green space.
Okay,
Why are we
but just
destroying
as a practical matter, what does that mean? Does that mean that, and how would it be weighed? Does that mean that wherever there's any incursion on open space, there should be a finding of a significant impact? I'm just trying to understand how you would have that operationalized.
question? I think what you do, identify and analyze and have community input when you're going to destroy 20,000 of open green space. What does that mean to the people in the community when you have a
But
negative
hasn't that
declaration?
been done by way of assessing what the open space impact is?
Has it been done? It wasn't done here. And the specific answer to your question is that you don't destroy a Liver Street garden when there could be reasonable alternatives When you look at the open spaces that they have, nothing's comparable. They're walkways between cars that are coming on both sides. You're talking about paved ballparks and playgrounds.
Okay, but that is something that they did assess, and I understand you disagree with the assessment, but those are points I think that they looked at.
But if you had an EIS, you would have the community input. Who, in Merson, your decision in 1997, says you can't have a bilateral process between the developer and the lead agency. You need to have the people in the neighborhood decide whether or not the existing uses are going to be sufficient if you destroy this oasis, this open space that reduces the fear of climate change and has so many other aspects.
So
The
is
answer
that-
to the question.
So is that at the end of the day, the issue pitting the need for affordable housing against the open space?
You can have both.
Okay.
You want both. I wouldn't be here. My clients are not NIMBY. We would not be here. I've devoted my life to affordable housing and senior housing. But there are alternatives. They didn't discuss the alternatives. You, in
So
a couple of cases, say,
Is there a proposed action that is small enough that climate change wouldn't need to be considered? Let's say it was 1 tree instead of 20 trees.
it's
Would you
a good
still- would you
hypothetical
still-
question.
Yeah, right, exactly. It
I'll
is.
answer it too. I believe every vote counts in America, every tree counts. However, we don't have just 1 tree. We've got many trees.
I'm
We
not
have
sure I understood
20,000
the
square
first
feet.
part of your answer. If it had just been 1 tree, would HPD have had the discretion to say, we're not even going to think about climate change because this is just 1 tree?
I say no, legally, maybe they could say that, but that's not the case here. We're talking about, I looked at all of these places, I went personally, and you look at these community gardens that they say are alternative, narrow pathways. There's nothing that you could have, movies, concerts, you can't have the Chinatown.
So is it your argument that the era of law here is that they simply didn't do it?
Yes. And also that it's not rational to conclude that it doesn't have an adverse impact. And second, that they never took a hard look. I go back to the question of climate change. No look. In the 153 pages, I was astounded. The word climate change doesn't appear. I understand courts, Supreme Court of the United States, this court, I put you on the same level. You're looking for something that's clean, that can go back, create some precedent, and the most important thing for a court, for lawyers, is to look at the laws that we have, CEQA, and show the public the importance of how those laws can combat these kinds of issues. How
you,
can you not
counsel.
address climate change?
Thank you.
Thank you all very, very much.
May it please the court, my name is Jamison Davies for the respondents. This court should affirm the First Department's unanimous decision straightforwardly applying well-settled law. The Department of Housing, Preservation, and Development, in this case, did exactly what the law requires. It took a hard look at the potential environmental impacts of the development for low-income seniors on city-owned
Are
property.
you required to look at climate change? And if so, what's the hard look on that?
So two points on that, Your Honor. First, I think if you look at, so they bring in climate change under this generic kind of policy element. And if you look at the technical manual, policy is talking about policies that are particular to that area. So for example, if you look at 876 of the record where they do the policy analysis, they talk about this one policy that does apply to the area. It's this basically making sure there's grocery stores, sufficient grocery stores. But I think they did take a look at climate change because it did do the greenhouse gas
I'm
analysis.
sorry, before you get to
Sure.
that, I'm sorry to interrupt you. On the first part, is it your position that you have to look at climate change?
I think you
You saying
have,
yes or no?
within the scope of the technical manual. So I think the greenhouse gas emissions is looking at climate change. That's the main driver of climate change, the biggest contributor to climate change. So I think you do have to
Did
do.
that analysis include, consistent with the question I was asking your adversary, was that a greenhouse gas emission with respect to the building, or was it also a greenhouse gas reduction with respect to the plant life?
It's with respect to the building, and it just is whether you hit these these threshold triggers that require further analysis. And so if you don't hit those threshold triggers, it
Where do
doesn't
you stand on the necessity of a greenhouse gas reduction analysis with respect to plant life?
I don't think that the secret process is so granular. I don't even know if the science is sufficiently granular to say how much greenhouse gas reduction you can get from 15 to 20 trees versus, a huge forest or something like that. I don't even know.
But clearly, you have to take into consideration open space,
Yes.
green open space and other regular open space. So let's get to that. I mean, I don't think there's a debate on the climate change analysis by the scientists that open space is critical to addressing climate change. So let's just stay with that one, huh?
Yes, correct, Your Honors. And I think, this is a reduction in open space
Yes.
of about 14,000 square feet. It's not, in the grand scope of global climate change, a significant reduction in open space.
But do you think that if the open space was completely paved, as compared with the open space being totally forested, I realize that's a little impractical in the middle of the city, but would there have to be any accounting for that differential in terms of its impact?
In terms of its impact on climate change?
Yes. I mean, I appreciate it would also have some effect, I think, on the way in which that space is used, but on the climate change point in particular.
I don't think within the scope of SECRA, and I think it's important to note that there are a lot of climate change policies that the city has, including, for example, the executive order.
So what's the
on knowledge.
interplay between those, the executive order specifically, and SECRA and the technical manual? Does the technical manual need to be adjusted to account for that? What's your position on that?
So I don't think it needs to be adjusted to account for that. I think it's just a matter of sort of achieving different aims. SECRA is driven towards trying to decide what the net, sort of marginal impact of a given project is going to be, whereas the executive order and other policies that the city is implementing are geared towards a global reduction in greenhouse gas emissions.
Council pointed out during his argument that the technical manual in use at the time of this review was the 2014 technical manual, which I think now has been updated by a 2021 technical manual. Does the analysis for climate change impacts significantly change for 2021? I get that you didn't use it, but has there been an evolution of the thinking on that?
I don't think it's significantly different. There may be some minor revisions. I'm not certain exactly what the revisions are between those two and climate change, but I don't think the analysis is significantly different. It's just
I guess here's what I'm grappling with. It may well be the case, and I don't know the science, you probably know it better than I do, that there's no way to gauge as a scientific matter what the impact would be of, let's say, 100 trees, pick your number, right, in terms of greenhouse gas emissions. But I think we could probably agree that adding them would be a plus in terms of reducing emissions, and getting rid of them would be something that would enhance emissions. So is your view that it doesn't have to be taken into account simply because you can't calibrate the exact effect, or is it something other than that? Because you could just say, well, it's a positive thumb on the scale as a general matter, right?
right. I think our position is that SECRA is not, I guess, to that level of granularity. It's to flag potential significant environmental issues for policymakers when they're making a decision. And I think these kinds of policy questions are properly in the Euler process, which is where everyone, which happened here, everyone had the opportunity to raise these concerns to the council. The city council voted unanimously to approve the project. And that's really kind of the policy arena where these questions are better resolved rather than SECRA, which is a more technical and procedural statute, which gives you, the need to basically just flag issues of concern and determine if they're significant or not.
So do you dispute the contention that public participation is baked into the SECRA process?
Public participation is baked into the SECRA process if you get to the environmental impact statement. Then the rules are pretty clear. If you have a negative declaration, there's no SECRA public participation element. There might be if it's a ULURP action, as there was here. But if you get to the EIS, then there's opportunities for public comment. So it matters whether or not you have a negative declaration or a positive declaration. And
Let me ask you to turn to the point that the Supreme Court was persuaded by when it comes to petitioner's argument. This argument that you all decided that the open space deficiency, which was acknowledged, right? There's no debate, there's no dispute that the open space is going to decrease under the project as currently proposed, that you all had decided that nevertheless, that loss of open space is somehow offset by what otherwise exists or might be made part of the project. Could you address sort of the Supreme Court's view that unfortunately, in her view, there was not really a hard look at what this amelioration would really be able to accomplish?
Sure. So I would say, there's about 20 pages of analysis in open space. It's 891 to 912 of the record. And the agency goes into detail. It says we're going to lose this amount of open space. And I would just point out, actually, it was using a conservative analysis based on what is currently there, but the city last week prevailed in its holdover action. So, Elizabeth Street Garden is going to be evicted regardless, and that's not necessarily, the analysis is even better for us at this point. But basically.
Oh, wait a minute, which means what?
Which means that the baseline is not necessarily.
Tenant is out, well, he's deceased, but what does it mean?
It basically means the city's going to take the lot back over,
Okay.
regardless, so that potentially there won't be open space there as a baseline.
It doesn't matter anyway?
The EAS used that as a conservative baseline, but the baseline in actuality might be 0 open space versus the additional open space that the new Haven Green project will give us. But as to the analysis that's actually in the record, it's basically that it'll be deeded in perpetuity. There'll be regulatory agreements to enforce that it's maintained. There's community input into how the space is going to be built, what it's going to do. There's a 7-member panel, a community advisory committee that includes open spais advocates that's going to talk about.
I'm
how
sorry, I
best-
was asking you to address the Supreme Court's analysis.
Right. What I'm saying is that is all of the things that offset the reduction in physical volume of open space.
That's the qualitative analysis that
Correct,
was
Your
done. But with respect to the quantitative part of that, I want to propose a possible rationale for the Supreme Court's decision. Tell me if it makes any sense to you. This area is well below the aspirational benchmark for open space for the city. And I get that it's in Manhattan, in a very populated area of Manhattan. It's not a surprise that it's below the benchmark. But could you not argue that in an area that's so far below what is ideal, that every bit of reduction of green space is all the more critical because you're dealing with an incredibly scarce resource at that point?
I think it is more critical, and that's what the technical manual provides, that the thresholds are triggered at a lower level if it's already an underserved area. But that just means you have to do more analysis and weigh the quantitative reduction against the qualitative increases in.
That's my point. What's the hard look on the amelioration? That's what Supreme Court said. It felt that there wasn't really an explanation of this amelioration, how it would really ameliorate that particular decrease.
Sure. So I would say that.
It can't be you're going to the Roosevelt Park. I mean, that's not going to be good enough. So it's got to be something.
The main thing I would say is that there is a increase essentially in the opportunity to use the open space because it won't be subject to the whims of a month-to-month lease. It will be open in perpetuity. It will be open for longer hours. It will be open year-round.
So let's say I had an open space of half a mile. It's a hypothetical. With a project, you reduce that to a quarter of a mile. The fact that the quarter of a mile is open 24 hours a day is what makes a difference if the half mile was only available 9 to 5?
I think as long as what SECRA requires is that the agency take a hard look at that trade-off and make a rational determination as to whether it amounts to a significant change. As long as the agency's done that, you and I might disagree about
It's a very difficult analysis you're positing. I mean, you've lost something, you're not going to regain it. You're just trying to improve whatever amount is left when the driver of the analysis is that a reduction is problematic.
Right, and I think that's why.
Any reduction is problematic, so
I
it's
think
very
that's
hard.
exactly why SECRA consigns to the agency's discretion the weighing of these kinds of potentially incommensurate things. It's not just a matter of which number is larger. You have to weigh qualitative versus quantitative effects, and that is within the agency's discretion to do. It's not for the courts or any of us to substitute our judgment for that weighing of factors.
Is there at any point where there's an aspect of judicial review on that particular issue? Or we always have to defer, hands off?
I don't think you always have to defer. If the analysis was completely irrational, if it made no sense, if it was, if they said.
Well, that's what Supreme Court concluded, right? That there wasn't a rational basis.
That is what the Supreme Court concluded. I think, respectfully, I think the Supreme Court got it wrong. The First Department correctly concluded that they did weigh these two factors and came to a reasoned conclusion, and that's all we need is a reasoned elaboration of the result.
And that reasoned conclusion is you have less, but what you have is quite good.
Correct, and then it's not likely.
Even though, as Judge Cantaro's already pointed out, you've already said what you have is not good enough. You're already starting with, this is not good enough.
Right, but the analysis only measures the incremental difference between the current situation and what will happen in the future. So that's all, that's the delta we're talking about. So, the fact that it's already overburdened is relevant, but it doesn't change the analysis. And I think that's just the weighing of those two sets of factors is well within the agency's discretion. And it also considered whether or not other area parks are likely to be overburdened as a result, what the access to things in the area. There's a long analysis of all of
There's only one other park, right? Or am I missing something?
No, Your Honor, there's I think like 21 open spaces. There's a table in the middle of the.
No, parks.
There's Tompkins Park and I think Sarah Roosevelt Park, along with a bunch of other smaller open spaces, playgrounds and things like that.
Both of those parks are quite overburdened, but okay.
Well,
Go ahead.
Yeah, I think that if you look to the analysis, it goes through every park in the area, every open space in the area, gives it whether it's in good shape, how burdened it is, and talks about whether or not that is the additional impact is likely to overburden those resources.
And also, I thought a consideration of how likely it was that the particular population might might be imposing a significant additional burden on those already strained resources.
Absolutely right, Your Honor. And it goes through and says, this is low-income housing for senior citizens. They're likely to use the parks at different times than the median person who's younger. They're more likely to use it during the day when people are at work, things like that. So it talks about the characteristics of the population as well. And I urge the court to take a look at the open space analysis. It's very detailed. Just one small point on the last issue, the zoning issue. It's unripe. I think petitioners kind of give the game away in their reply brief when they say that you don't have to defer to BSA. BSA hasn't even weighed in yet because the procedure is for permits to be issued, and then if there's an appeal, BSA can weigh in. So the zoning issue is unripe at this point. And unless there are any other further questions, we urge the court to affirm.
Thank you.
A lot to say. Community participation. This court has on numerous occasions pointed out the importance of community involvement. Let me give you an example. When the community later was able to go and speak at the ULURP, it's too late. It's over. They already decided on the CEQA stuff. So that's an example. When they talk about open space, when they talk about the changes, what better? When you talk about seniors not going to those places, why should the developer and the lead agency decide whether seniors are going to go to those places? I've been to those places. When he talks about one park, Sarah Roosevelt, it's not the kind of comparable to open space. They talk about Tompkins Square Park or Washington Square Park. Not only are they're not in the study zone. Seniors are going to walk there 20 minutes later. It's a completely different environment.
Counsel, when you make that kind of argument, it almost sounds as if it's not the agency and the developer who get to decide who's going to go to that open space. It's me and my clients who get to decide who's going to go. Why should we substitute your judgment for the people who are charged with administering SECRA?
Take a look at Friends of PS 163, where they talk about it's essential and mandatory that the community be involved. I'm not talking, I'm using your case law over the years to develop this argument. You've said it over and over again. Let me also respond to the other questions that were being asked. With regard to the idea of the greenhouse, the technical manual 18 is greenhouse and climate change. They're two different concepts. And when they talked about that they did the look at greenhouse, go to page 860 of the record. It has nothing to do with climate change. When they list all the factors that they took into account, greenhouse is there, climate is not there, page 862. With regard to the issue, with regard to the greenhouse, it was all about the building. You're right, it wasn't about what's the effect of open green space when you're destroying it, and how does it coincide with trying to counter climate change? There were hypotheticals posed to me about 1 tree versus 100 trees. We concede you could defer to the agency if they do a hard look, but not when they do a no-look. There should be no. And furthermore, on discretion, under discretion, it's not unlimited. I submit when they don't do climate change, it's an abuse of discretion.
What, if any, impact, I know it's post, it's outside this record,
I'm
but
sorry?
since he mentioned it, what, if any relevance does the result of the holdover proceeding have?
It's irrelevant. They're separate and distinct. An appeal has already been filed. There's a stay until September 10th. There's lots of creative legal options to deal with the housing courts in New York City. It's irrelevant. We're separate and distinct. We have enough co-appellants that Renee Green, who lives there, under plastics, under Save the Bush, she meets every one of those criteria. If every one of our plaintiffs, appellants disappeared at all, she's there, 92-year-old woman, wonderful. I talked to her the other day. She goes there at least once a week, even
Thank
though
you, counsel. Your time's up.
I appreciate coming here, especially after going to the appellate division, and you'll do more than that 4-page decision. Thank you very much.
Thank you.